discussed in the Committee of the Whole, not as a constituent assembly or a constituent convention, neither a PI. So that means that during the period of bicameral committee, is it possible that the bill or the House resolution will be altered and putting some amendments? Kasi Mr. Speaker, we have that experience, right? If the sponsor would agree with me, there are bills or resolutions na agreed na, Mr. Chair, Mr. Speaker, distinguished sponsor, on a third and final reading, but there is a third Congress, what we call the bicameral committee, wherein meron kasing kumbaga malaki yung mga significant na changes as regards to the amendments in the House resolution or bill. So would it be possible na magkakaroon din ng amendments later? So if there come a time na nagkaroon ng bicameral committee between the House and the Senate, may possibility po ba na magkaroon ng amendments doon sa BICAM?
I would like to assure our distinguished colleague that there will be no chance for a bicameral conference committee because our RBH 7 is identical to RBH 6. So there is no chance. Those who conjure fears that there may be some political amendments will really be unfounded because it's very clear in the Senate, 3 articles, 12, 14, and 16, the same here in the House of Representatives. There is no chance that there will be any change to what we will approve here and what will be expectantly to be approved in the Senate.
Mr. Speaker, with due respect, no, sir, there is a big difference as regards to the on the term on like voting jointly and voting separately. Here in RBH 7 that we have approved. So sinasabi natin dito, Mr. Chair, Mr. Speaker, distinguished sponsor, that the Congress will vote jointly.
Yes.
Pero sa Senate po, ang version nila, voting separately. So that would be different and a big different,
That you are talking about procedure, distinguished colleague. Now, in the procedure, while ours here, we went into a committee of the whole House, that was not yet Constituent Assembly. Now, we are now Constituent Assembly. In other words, the procedure will be the same. They have 3/4 vote in the Senate and 3/4 vote here, which will comply with Article 17, Section 1, Paragraph 1, 3/4 of all its members. It does not require a joint session.
Okay, so in our resolution on both houses, no, so we have said here, so what are we talking about? Yung Congress, which is composed of the House of Representatives and the Senate, Mr. Speaker.
That's correct,
right?
Mr. Speaker.
So, so yun nga po, di ba, if this is a constituent assembly, the House of Representatives and the Senate should convene jointly and vote separately. Tama po ba yun?
Mr. Speaker, that was the 1973 Constitution. And the 87 and 73.
Yeah, 1987.
In the 87 Constitution, there is no statement about joint hearing in joint session of Congress assembled. It is the 73. So if you have constitutional construction, Mr. Speaker, it means that that requirement to have a joint assembly in joint session assembled, not already stated in the 1987 Constitution, in constitutional construction, that has been set aside. So there is no more need for a joint session. That is why, in this particular case, the Senate and the House is having its own contemporaneous construction. There in the Senate, they are now doing it at the subcommittee level on into a process of getting 3/4 vote of the Senate. They've already started it. If they did not believe in a non-joint session, then they would have called for us together. There will be no more committees. Go direct to a joint constituent assembly. The same construction we have done in the House because we went through the committee on the whole, and now we are here on a plenary. And so therefore, this constitutional contemporary construction of both houses lends credit to the fact that the both houses of Congress have made the determination that we are following Section 1, Paragraph 1 of Article 17.
Thank you, Mr. Speaker, and our distinguished sponsor. Okay, just for the record lang, Mr. Speaker, no, as later on, if there would be some amendments, I just would like to put this on record. Yeah, the answer, Mr. Speaker, of our distinguished sponsor. So, would there be a political amendments like in term extension, term limits, etc.?
Nothing of that sort whatsoever, Mr. Speaker.
Thank
The
you.
four corners of our resolution and the committee report 985 is definite, specific, and clear. Only three economic amendments. So that will never happen, that there will be political amendments. We assure our distinguished colleague.
Okay, I just would like to put that on record because there would be BICAM and there would be some discussions further. How about the substantial amendments on Bill of Rights, safeguards of martial law, the ban of nuclear foreign military bases, and on those Bill of Rights, safeguards of martial law, and the nuclear and foreign bases. So pwede po ba yan na maaring ma-amend or mabago during the BICAM?
Absolutely none, Mr. Speaker, on the subject matters that was stated by my distinguished colleague. Only three, Article 12, 14, and 16, economic provisions by putting there unless otherwise provided by law.
Okay. Thank you, Mr. Speaker, distinguished sponsor, or for that assurance. Dahil alam niyo po, talagang marami rin tayo naging mga karanasan po, no, na naging malaki yung naging pagbabago when there is already when the bill or House resolution is already in the BICAM, Mr. Speaker. Well, next question, Mr. Speaker, yung tungkol doon sa on the I'm just curious about our claims in the West Philippine Sea. If there would be a opening up of our opening up of our public utilities and to other aspects of economy, so what would be its effect to our claim in the West Philippine Sea, if there is?
There will be no effect as far as the economic provisions are concerned. None whatsoever. Our claim continues. We have won in the Arbitral Tribunal of July 12, 2016, stating that the Chinese position of the 9-dash line has no basis in international law, specifically the United Nations Convention of the Law of the Seas.
Okay, so there's no connection whatsoever, and also
None whatsoever,
Okay.
just economic provisions.
Okay, so suppose RBH 7 would be approved. So ibig sabihin, Mr. Speaker, yung public utilities natin ay maibubukas na po, no, sa ating sa foreign ownership. So that includes water, yung ating electricity, transportation, telecoms, etc. So as of now, ang condition po natin on our power, Mr. Speaker, distinguished sponsor, as regards to the transmission and distribution, it is still in the hands of Filipino majority,
Yes,
right?
that is correct.
Yeah.
60-40.
Yes, kung maibubukas po ito, halimbawa, Mr. Speaker, when this would be approved, so ibig sabihin po yung transmission and the distribution will be open to the foreigner.
That is correct. However, what we approve now, if we approve it, is a provision that it will be, unless otherwise provided by law, Congress will now determine what will be the percentages in the opening up of our industries, public utilities. At the same time, like what the United States and United Kingdom has done, they have a Foreign Investments Act and National Security Act. In the US 2019, in UK 2022, there will be screening of investors to our country. And therefore, countries in conflict with our country may be not allowed to invest because there is a conflict. And that is precisely what the US and UK have done, that there are laws to screen those who will invest in their respective jurisdictions.
But, Mr. Speaker, there would be a possibility. Kasi nga, di ba, i-open na natin, not only, i-open natin yung transmission and the distribution to foreign entity. So as of now, the condition is 40%, and our national grid, 40% for Chinese, for China, and then 60% for the Filipino. And sinasabi niyo po, no, it would be dependent on the legislation or
That's
dependent.
correct.
Yeah.
To
So,
put some safeguards
Yeah.
on the investments here in the country. That's
Yes.
correct.
Siguro, Mr. Chair, in the future, kung hindi na rin tayo siguro yung nasa Congress or nasa Senate, maaring ibukas na yan ng 100%. Kasi sabi natin, gusto natin talagang i-full open yung mga public utilities natin. So, would there be a possibility po na even if it is not China or if it is US, kasi ito nabalitaan natin, mag-i-invest daw po yung US dito, no?
1 billion.
1 billion. So if it is not China, if it is other countries, would it be possible, Mr. Speaker, because of the word unless otherwise provided by law?
In the realm of possibilities, yes. It can be 100%, 99%. However, this will be lodged in Congress to decide what are the safeguards, how much will be the investment ratio, and what countries, what will be given to our NEDA, to our executive department, the standards to be able to protect national security.
Okay, thank you, Mr. Speaker and distinguished sponsor for that explanation. Next question, as regards to the flow of our FDI. So, medyo natigil yung pagka-question ko to NEDA about the how much pa ba yung kailangan nating i-open in our economy since lahat na ay open na, no? Like for example, yung mga manufacturing, yung mining. So kahit naman yung sa part ng ecozone, so kahit na rin siya, no? Marami na rin tayong ibinibigay na mga concessions, etc. So, how much percent pa po ba sa economy natin ang i-open? So, ilang percent pa po ba? Do you
That
know
is
the percent?
precisely what, in the ultimate wisdom of the two houses, chambers of Congress, will decide. It will be subjected. Any bill regarding opening of investments after we approve this amendment will be subject to the positions of NEDA, DTI, the National Security Council, the Department of Foreign Affairs. So everybody will be heard. The point is that there is flexibility because it will not be carved in stone like what we have now. It is in the Constitution, and that Constitution, until amended, is the fundamental law. And that is what we're trying to lift so that Congress will be able to hear all stakeholders and then be able to decide what will be the best foreign investment law on certain industries.
Yes, Mr. Speaker, I'm asking of the percentage of our economy that is still closed.
Precisely.
So, if you are going to open na yung lahat ng utilities,
Yeah.
yung education institutions natin,
Advertising.
and advertising. So, ilang percent pa po yung natitirang not open to foreign investment?
We do not have any agency those particular figures. And the best way to have that is when we amend this Constitution and we will go investment by investment in every field, Mr. Speaker.
Okay. Thank you, Mr. Speaker. So, dun po sa research natin, no, at least 6% na lang po. 6.2% na lang yung hindi open for foreign investment po doon sa ating doon sa ating study. So, but anyway, doon po sa mga pag-aaral like why foreign investors do not go to the Philippines. There are, di ba, may mga study po about the, number one, yung cost of electricity, the cost of internet, and then our policy, economic policy, and then yung, yung mga permitting, both for LGU and national, and then yung pong traffic, corruption, etc. So, wala po ba tayong titignan na magiging, na ito yung nagiging cause why yung ating mga supposedly foreign direct investment na pupunta rito sa ating bansa, yun po yung nagiging dahilan. So, are we not going to scrutinize then or have a study, survey about those cited in the survey why why our foreign investments or why foreign investments do not want to go to the Philippines?
Thank you, Mr. Speaker. In my sponsorship speech, I said that opening our country through constitutional amendment is not the panacea to all the problems that we face. In fact, we are constantly trying to solve these problems of high electricity costs, problems of poverty, problems of high cost of doing business. But precisely, this will start, the constitutional amendment opens the key. And together with a set of program to be able to solve these perennial problems, then we will be able to solve the problems of lack of foreign investments to give more job opportunities to our people, Mr. Speaker.
Yeah, Mr. Speaker, thank you for the answer. So, wala po tayong gagawing later on na study or survey, pag-aaral tungkol doon sa mga sinasabi ng mga investors natin. Sa mga cost. Aside
we will
from,
continue.
kasi wala po tayong wala po tayong doon sa mga survey and study, hindi naman po lumalabas doon yung charter change.
Yes, but precisely, there is no mention of the charter change because there's no charter change. We are really, being cornered in a constitutional provision that limits foreign investment. So they're not factored in. But if we open them, then precisely then it's possible that you will be able to lower electricity costs by allowing for investments to come to generation, transmission, and distribution. So we are not going to stop our studies and surveys through our different agencies on the other issues facing us. We will continue. However, what I'm saying is that now we have a more open economy because we have lifted these provisions that are carved in our Constitution.
Okay. So, Mr. Speaker, Mr. Sponsor, since 1970s po, open na po yung ating mga investment, no? FDIs natin. And in fact, the Philippines has steadily opened up for foreign investment since the Marcos time in 1970s. The annual direct investment inflows are negative $4.1 million in 1970 and 22 million in 1971 dollars. And then when we welcome the economic policies no, under the Marcos Martial Law, yung foreign capital increased its investment after 1972 po by fivefold. Naging $131 million po yung ating mga FDI inflows, no? And tenfold in 1977. So during that time, 1977, we have 210 million US dollars. So kung titignan po natin yung magnitude ng FDI inflows increase in 1990s, especially in the 2010 to reach to 10.5 billion in 2021. They also grew measured as share of gross domestic product and increased fivefold from 7.5 of the GDP in the early 1970s to 2.6 in the last 5 years. So, kung titignan po natin mula panahon ng martial law, tumataas naman po yung mga investment natin dahil ang claim po talaga natin na bukas naman yung ating investment. Pero, did it translate to the condition on the poverty level, employment level of the Filipinos po? So hanggang ngayon po kasi parang lalo tayong naghihirap at saka yung ating employment rate, unemployment rate ay tumataas. So tingin niyo po ba itong pagbubukas natin, itong sinasabi natin na tatlong provision na ito ay makakapagpaalwan sa buhay ng ating mga kapwa Pilipino po, Mr. Speaker?
We firmly believe, Mr. Speaker, that we have here, in my sponsored speech, we have the inflows of inward foreign direct investments, and I'm having the 2010, 14, and 22. Although, yes, we have increased. From 2010, it's 1.2 billion. In 2014, it was 5 billion. 2022, it is 9 billion. However, we are left behind by our other ASEAN neighbors. Well, we were getting in 2022, just 1.5 years ago, well, we were getting 9.366 billion. Indonesia was getting 22 billion. Malaysia was getting 17 billion. Singapore, 141 billion. Philippines, 9.3 billion. And so therefore, we are saying that while we are indeed increasing, these are incremental increases. We want an increase that will approximate, there you go, we want the one that will approximate the other countries, like Singapore, Thailand, and Malaysia, and Vietnam. And that is why we are saying that this is really the needs of the times. Also, Mr. Speaker, the NEDA estimates that lifting the foreign equity restrictions on public utilities, advertising, and education could, on average, increase the real gross domestic product, GDP, by 40 to 80 billion, or an additional 0.2 to 0.4 percentage points to the real GDP growth. In other words, 40 to 80 billion will come in to the Philippines in real gross domestic product. Secondly, according to NEDA, this will generate, and it is the most important thing for all of us Filipinos, opening our country to lifting the foreign equity restrictions in public utilities, education, and advertising. It will generate additional about 40,000 to 130,000 jobs annually. Can you imagine that? 40,000 to 130,000 jobs annually. So therefore, we can say that indeed, even the NEDA is, of course, supporting this, as stated by Director General Arsenio Balisacan, because of the need to have more foreign investments, more job opportunities, and more income to the national government in terms of taxes.
Well, pinakita niyo po kanina yung yung data,
Yes.
Mr. Speaker, as regards to yung FDI inflow po
Yes.
nung ating mga kapitbahay,
Yes.
kalapit bansa. So, ang ibig bang sabihin nito ay yung pagkukumpara ba ng FDI inflows ng iba't ibang mga bansa. So, halimbawa kung tayo, so does it mean na nagbunga ito ng hindi pag-unlad sa atin at pag-unlad naman ng mga mamamayan sa ibang mga bansa? Kasi kung ikukumpara po natin, Mr. Speaker, as regard doon sa situation, so kagaya nga ng sinasabi ko, hindi lang yung FDI inflows ang magiging sukatan. So bakit ba dumarami yung pumupunta sa Vietnam, dumarami yung pumupunta sa even in Cambodia?
Yes.
Because of other things, not the provision on our economic chacha. So, kagaya ng binanggit ko kanina, Mr. Speaker, distinguished sponsor, yung problem nila on the cost of electricity, the cost of internet, kahit naman po sa cost of internet, Mr. Speaker, as compared dun sa mga ibang mga bansa, tayo yung pinakamahal. Kung-compare natin yan sa Vietnam, Malaysia, Indonesia, and even Cambodia, tayo po yung pinakamahal. Kaya yun po yung sinasabi natin. Kung susukatin lang natin yan sa inflows ng mga FDI, so hindi ito yung sukatan para masabi natin na umuunlad yung ating mga mamamayan. So, Mr. Speaker, distinguished sponsor.
What we can say, Mr. Speaker, is that all these countries which have higher foreign investment laws, they have no constitutional provision prohibiting and limiting foreign investments. So they are open. That's why in the Competitiveness FDI Restrictiveness Index coming from the OECD, it is very clear that the Philippines ranks 82nd out of 84 economies in terms of restrictiveness or being closed. So we are, 84 economies, and the Philippines is 82nd restrictive index. So we are saying that while other issues of high electricity, high cost of internet use, once again, we will emphasize that the problem also which we want to address is the constitutional side, why foreign investments are not coming to the Philippines. But we have to solve the other problems, and that will be precisely what the government is always doing together with its agencies and departments.
Okay, thank you, Mr. Speaker, distinguished sponsor. As regards to the manufacturing, so ito po ay open na po talaga.
Manufacturing has always been open. It's not.
Pero bakit po matumal yung pagpunta ng mga investors dito sa manufacturing and even in mining? Okay? So ano po ba yung sinasabi ng mga investors natin. Bakit ganon?
Well, there are
Diba,
certain
open na yan
industries.
yung ating mga manufacturing, yung
Yeah, there have been
and
always
even the retail, 'di ba? So kahit saan ka man pumunta dito, may mga foreign investors na, Korea, Thai, Vietnam, sa mga ano natin sa mga commercial areas natin. So
yeah.
kulang pa po ba itong mga mga batas na yan na nagpo-provide ng pag-openness ng ating economy doon sa mga mahalagang industry po, Mr.
There are industries that are already open and they are not in the constitutional list. However, precisely, Mr. Chairman, we are trying to solve the issues of electricity, of high cost, but at the same time, we should go back again to the constitutional provision to have more investments in public utilities, education, and media. And that is why we are saying that this does not solve all the entire problems that we have, but it can lead to the start of a new era where foreign investments will be coming to the Philippines.
Okay. Thank you, Mr. Speaker, distinguished sponsor. I will go now to education, Mr. Speaker.
Okay.
Distinguished sponsor. On our committee report, so section 4 on basic educational institutions other than those established. So gusto ko lang put on record yung tungkol doon sa pag-open up natin doon sa mga educational institution. Is it from elementary, basic education, elementary, high school, senior, tertiary level, hanggang dun sa kung may vocational or TVET, etc. On that level po, yung pagbubukas natin nung section 4 on Article 14, Mr. Speaker.
Mr. Speaker, on the point of education, we'd like the Speaker to recognize the Honorable Roman Romulo, our chairperson of the Committee on Basic Education, to be able to answer, as one of the sponsors, to answer this very particular issue on education.
Congressman Roman Romulo, you're recognized.
Thank you, Mr. Speaker. Thank you, Honorable Chairman Rufus Rodriguez. To the query of the lady from the ACT party list, it is clear from the inclusion of the word basic in the amendment that the liberalization will actually apply only to the higher education institutions. Basic education shall remain with Filipino citizens and with a corporation 60-40 owned by Filipinos
Okay.
and controlled.
Thank you, Mr. Speaker. Kasi meron pong dalawang kumbaga nagbabanggaan na provision. Like for example, control and administration on educational institution as regard doon sa kasi merong unless otherwise provided by law as regards to the ownership. Okay? So how
Yes.
can we harmonize that,
Actually,
Mr. Speaker?
Congresswoman Castro, the current constitution, the first sentence in Article 14, Section 2, Section 14, Paragraph 2, provides education institutions. And that is why everything flowed from there. If you will note, the proposed amendment under this House Joint House Resolution, it says, the first sentence says basic, and then even control, even ownership, and even the increase of Filipino ownership was all put together in one paragraph to emphasize that the intention is for all these sentences, all these prohibitions, all these powers to only apply to basic education. So if you will read, basic institutions shall have that 60-40 and owned by Filipino citizens, and control and administration shall be with Filipino citizens, and if there will be any increase in percentages of ownership, that will also be vested in for Filipinos in basic education only.
Yes, that's precisely bakit niyo po nilagay yung unless otherwise provided by law. Kung talagang, kung i-maintain po natin, halimbawa, doon sa basic education, that it is 60 to 40% in favor of the Filipino, ano tong magiging, etong nakakalito kasi ito, unless otherwise provided by law, kasi there is still a room, no, for changes later on, 'di ba? Sa 60-40.
Yes,
Percent,
but let me assure
okay.
the lady from ACT Party List that the sole intention of the authors of this particular provision is simple, that basic education shall remain with Filipino citizens or with a corporation, 60-40 owned by Filipinos. Control and administration shall remain with Filipino citizens and for basic educations, and the increase, if ever, in equity participation in basic education for Filipinos will also be in basic education. If there is some confusion brought about by the wording, we will take note of that. But let me assure the lady from ACT Party List, the intention of the authors is basic education remains with Filipino citizens, control and administration remains with Filipino citizens, and if there will be any increase in participation for Filipino citizens, that will also only apply in basic education. That is the intention, and if there's any confusion by the way it is drafted, this exchange between myself and the lady from the ACT Party List should clarify that issue, that the intention is basic education remains with Filipino citizens or corporations controlled by Philippine citizens.
Okay, so are you willing to delete itong unless otherwise provided by law? Kasi there would be a room further, di ba, in aid of legislation na maiba yan. Although we are discussing na malinaw na sinasabi ninyo that basic education is in control of the Filipino citizen pa rin. Pero the inclusion of this unless otherwise provided by law will provide a room for any legislation in the future, Mr. Speaker.
Hopefully, the exchange between the lady from ACT Party List and myself will clarify this issue, and under statutory construction, if there is any confusion as to the reading of any provision, then we can take a look at the deliberations and debates. And once they look at this deliberation and debates, it will be very clear to any person, any individual, including the Supreme Court or any court, that the intention of the authors on this particular provision is that it remain with Filipino citizens.
Yes. Okay. But of course, Mr. Speaker, distinguished sponsor.
But we note the concerns of the lady from ACT Party List, and we value always the opinion of the lady from ACT Party List, and we will take note of that, and I'm sure even the authors are already thinking about exactly if rereading this, if this will really create any confusion.
Well, thank you, Mr. Speaker, distinguished sponsor. So, ibig sabihin po, Mr. Speaker, yung tertiary level o yung higher educational institution will be open for 100% or whatever percent na ownership sa foreigner, including the control and administration of educational institution. Am I that would be the implication of this, di ba? Mr. Speaker, distinguished sponsor, the amendment.
That is correct.
So, ibig sabihin, yung mga higher education, open.
That is correct. Subject, of course, to laws that we have in our country now. Like example, sa CHED po, hindi naman CHED will have to approve the programs that will be taught or introduced by any higher education institutions. In fact, as Justice Puno, when he was one of our resource persons here, if you recall, Honorable Castro, in fact, one suggestion of Honorable Justice Puno then was that if we just delete all these provisions in the Constitution, then by law, that will still be open to Congress to be able to either limit it, subject to the environment, subject to experience, subject to how things will turn out. But theoretically, you are correct, but it is of course subject to Philippine law, rules, and regulations.
Yes, eto lang, gusto ko lang linawin din po. So, sinasabi niyo po na, kahit na po sinasabi ni Justice Poon na burahin yan, yun ang tanong ko basic. So, yung higher education, i-open na po natin yan sa ownership, control, and administration ng foreigner, 100% to the maximum.
Yes, and let me put in the records. Again,
included po dyan?
let me reply first, Honorable Castro. In fact, if you recall, during the Committee of the Whole, we discussed the Constitutional Commission's deliberations at that time. And in fact, it was noted here and told to us by one of the resource persons that Commissioner Gascon was asked for the reason for why we have this constitutional equity restriction. And if you recall, the reply then was that for values. But at the time, the environment at the time was there was no social media, there was no cable TV, there were no cell phones, and right now, the environment is far different. When you enter college or HEI, you're 18 years old. You're already an adult, and with a solid foundation that we give in basic education, we know that all those reasons for the inclusion before will no longer exist.
Okay, with that argument, Sir Speaker, mas lalong napatitibay po no, yung ating paniniwala na hindi naman kailangan na i-open natin ito 100%. Kasi with meron na tayong mga distance learning, di ba? Or pwede tayong meron nga tayong trans-international na law na hindi pa natin, sabi nga ng ating resource person, na hindi pa natin to naya-apply. Kasi
correct.
Pandemic ito
That
na ano. So with yung reason na yon, dahil meron na tayong social media, meron na tayong mga like yung mga applications, etc. So the more na hindi naman kailangan na i-open 100% yung operations, control, and ownership doon sa higher education. So, yun po.
Yes.
And another question, kapag inopen natin sa foreigner yung higher education, does it include the land ownership? Kasi yun di ba? Yung control and yung control ng mga educational institution natin. So ibig sabihin nun, it is a subtle way na binibigay na natin sa foreigner yung lupa. 'Di ba? Kung mag-open tayo ng 100% na ownership.
Honorable Castro, I am sure you are well aware that there is a specific constitutional provision on land ownership. That is not being discussed here. And even if we open up the higher education institutions to ownership, that constitutional restriction remains. So the land is not included within this discussion. What is included here is simply the ownership of the school, a higher education institution. And I'm very happy, Honorable Castro, that you mentioned yung mga online HEI programs already. In fact, ang dami niyan. In fact, recently nabasa ko, Harvard in fact is giving free online classes. And that is one of the reasons why, the very reason why we had the restriction is no longer valid. Because with the coming of social media, with the coming of Wi-Fi, we are already open to the world. The influences that constitutional framers sought to prevent then, because there was no Wi-Fi at that time, no longer exist now because we have Wi-Fi. The influences are all over. Pangatlo,
Yes,
third, Honorable Castro, matagal na tayong magkasama. In fact, we have been fighting for our teachers, and we both know the truth that we need better quality universities and colleges in the country. We need them because our teacher education program, we have not been able to pass in our own LET examinations more than 50% of the LET takers for basic education or secondary education from the years 2012 to today. So we really need to upgrade. We need quality in our teacher degree programs. We need quality in our universities. Competition will bring that. competition will bring quality, efficiency. And just to mention, you mentioned kasi po yung yung transnational, yes, yung higher education. But again, to put it in the proper perspective, if you recall, Dean Abad from Adamson University, when I asked about that query on this particular law, it is not really, it is merely partnerships. It is really just opening a branch office. It is not really, at the end of the day, the full service that we want to promote quality in our schools. And Dean Abad herself mentioned that what we have here are really just branches. It is really partners. So ownership is not really in the hands of the foreign institution. But just to put it on record, as of now, we already have 26 foreign schools with foreign partners already. But again, this is not what we contemplate. What we contemplate is really that the university or the college itself comes in, takes full control, and they are the ones that are able to direct the curriculum that they want to introduce in the Philippines.
Well, ang problemang sinosolve natin, Mr. Speaker, distinguished sponsor, if I remember it right, dun sa ilang mga sponsor na nagsalita, and even the pro-Chacha colleagues, ang sinasabi natin, yung gusto nating ma-address, yung education crisis, yung learning crisis. At sinasabi natin, ito yung result ng PISA, ito yung ganito. So kung hindi kasama dito yung basic, no? So minention ng ating ilang mga resource person about the problem of our education,
Yes.
'di ba? Yung access, yan yung recommendation ng EDCOM 2, ako naniniwala ako talaga doon
Tama.
sa majority ng mga findings na yun yung dapat na i-address.
Yes.
Hindi yung ownership. And in fact, yung sinasabi natin sa tertiary level, hindi naman nauhuli yung ating mga universities, yung mga top universities natin, dun sa mga top universities ng other school.
I fully agree.
Hindi po ba? So, graduate ka ba ng Harvard? Graduate ka ng Yale? Graduate ka ng SNU? Graduate ka ng ganito? Ay magaling ka na at makakatulong ka na sa taong bayan at magagawa mo ng paunlarin yung buhay ng taong bayan. So hindi pa rin yun yung sasagot sa problema natin sa edukasyon, Mr. Speaker. Mahusay tayo sa higher education, ang dami natin magaling na school, na competitive, na hindi naman kailangan nating gawin yung pag-open nito ng ownership, administration, and control ng foreigners.
First of all, for the lady from ACT Party List, we both agree, and I think all the members will agree, that we have full faith, first of all, in the talent of Filipinos. Wala po tayong issue dyan. Ang gusto lang po natin ay siguraduhin na mas marami silang pagkakataon na yung ma-harness po nila yung potential nila. Tama po kayo. Binanggit ninyo yung EDCOM 2 Year 1 report. And that is correct. Marami po doon findings iba-iba. Pero let us not forget that EDCOM 2, in fact, identified 28 priority areas. And one of the 28 priority areas would be the internationalization of higher education institutions. The reason why the first year report tackled first the 23 points, not including yet HEI's, internationalization of HEI's, is because the view then of EDCOM 2 was yung unang mga issue ay mas madali, in a sense, mas low-hanging fruits. Bakit? Wala naman po doon constitutional prohibition. Unlike when you talk about one of the 28 is the internationalization of HEIs, we all knew from the very beginning there was a constitutional barrier. So it is not easily within the low-hanging fruits. So natakil muna yung mga walang constitutional barriers. Pangalawa, even if you take a look at the EDCOM 2 Year 1 report, and it was very glaring po doon, one of the improvements that we must do is with respect to our teacher education programs. Hindi ba po, mali nga ako kanina, from 2009 to today, hindi ba maliwanag po doon yung average passing rate ng let takers natin ay sa primary and sa secondary, less than 50% pass the let on average.
Well,
Hindi pa po yun. Meron pa po tayo more or less mga almost 200 HEI institutions operating since 2012 that in fact have not produced any passers in our LET exams. And the teacher is the most important ingredient for education. Yun naman po talaga ang pinaka-importante. Sabi nga po natin, di ba?
Yes, Mr. Chair, I
A
believe-
happy teacher is really equivalent to quality education. Sinasabi rin po natin, marami tayong magagaling. Wala ho tayong issue. Marami tayong magagaling na HEIs. Ang sinasabi lang natin, mas maganda pa kung magdagdag tayo. Unang-una, competition will be able to promote quality and excellence. But then again po, no? We have a lot of HEIs that are doing so well, but what is wrong with us even providing our learners more opportunities?
Yes, so sa sinasabi natin, Mr. Speaker, so hindi naman ang cost doon ay yung ownership o yung control, yung administration. So kung meron bang mga foreigner dito, so tingin nyo ba 100% na yung passing sa LET? 100% na yung magiging passing sa medicine or any courses. So yun lang po yung sinasabi ko, Mr. Speaker, na-determine natin yung problema ng mga educational system natin, especially in the tertiary level, na-determine natin. Pero hindi yung ownership or control and administration ang problema doon. Ang problema po ay yung system. Kahit naman po mag-internationalization tayo na sinasabi sa EDCOM, ano po ba yung internationalization? Does it include ownership and control and administration of our HEIs? Yung po bang ibig sabihin ng EDCOM on internationalization?
First po,
Mr.
para maliwanag, it is included in the 28 priority areas that was released by EDCOM 2 year 1 pa lang. Pero ngayon pa lang siya maumpisan i-discuss simply because may constitutional barrier nga po eh. That is why that was an issue that could not, hindi siya low-hanging fruit. Now, if you will ask me, kasama ba po yun? I'm sure it is an open menu kung ano yung pwedeng pag-usapan. But of course, it will be discussed within the limits of our laws, most especially the Constitution. So right now, kung pag-uusapan po yun, definitely, mahirapan po talaga yung discussion about that if the Constitution is closed. Because, or limited or restricted, because EDCOM 2 can only work within the parameters that it is given. But the fact that it was placed in the 28 key priority areas, I think is a signal that there is really some concern. Tama po kayo, baka naman hindi naman yun hanggang doon ang patungo. Pero hindi rin po natin malalaman kasi nga sa ngayon, may equity restrictions tayo and EDCOM 2 cannot go beyond that. And again, Honorable Castro, if I had misunderstood you earlier, alam ko naman yung sinasabi po ninyo, it's the system that must be fixed. And that is what we all are in agreement with that. But we should also agree that there are many and various ways that we can improve the system. And one such way is to improve our teacher education program. And one way of improving that, again, is through competition. And once we have more quality education in universities, that may provide quality education.
Well, thank you for that explanation, Mr. Speaker. Alam niyo po, marami na rin tayong mga magagaling na mga teachers ang nagpupunta. Hindi lang sa US, kahit na dito lang sa ating sa ating mga neighbor countries because of salary. So yun din yung dahilan kung bakit kung bakit nagiging problematic tayo doon sa mga magagaling na teacher sana or even siguro sa mga newly graduate na makikita nila yung ating may salary na ganito na hindi talaga enticing sa ating mga magagaling na mga newly graduate and even yung mga magagaling nating mga teachers nagpupunta na rin. So iyan din yung dapat nating pag-ukulan ng pansin. Although meron na rin tayong ginagawa, pero hindi rin yan yung magsasabihin natin na kailangan nating 100% ownership yung ating Tama kayo, system, yung ating policy doon sa ating education, yun po yung dapat na palitan. Yun po yung dapat na gawin dahil naniniwala pa rin talaga ako na best education pa rin ang makukuha natin sa Pilipinas. Kahit na sabihin natin na magagaling. Kasi applicable sa kanila yun eh. Iba yung sa atin, di ba? Yung dapat na maituro dito sa atin, sa ating mga kabataan, eh yung concepts, skills na pakikinabangan natin at hindi ito yung pakikinabangan ng ibang bansa. So, yun lang po yung ating masasabi doon na dapat ang edukasyon natin ay wag namang ituring na parang goods, 'di ba? Na for sale, lalong-lalo na sa higher education. At it's good nga nalinaw ninyo na hindi kasama yung basic education dito, Mr. Speaker.
Yes.
So,
And-
yun ba
And
po?
Honorable Castro, we agree with you, no? In fact, I've always stated that with the issue of education, this is not, from my point of view, it is not about investment, it is not a commodity or a good. It is simply what we want is to ensure that our number one asset, yung potential po talaga ng Pilipino, ay ma-unleash natin, hindi lang sa ating bansa, pero kung kaya natin globally, because that is how good the Filipinos are. And that is why we want to ensure quality education. We are not saying that we don't have enough good teachers. Marami rin po tayo. But you must remember, napakarami rin po natin Pilipino. Kung maalala po ninyo, ang dami rin naka-enroll sa ating mga paaralan. In fact, tayo nga sa basic education, we are trying to free up our teachers from the admin work. Because sobrang dami ng trabaho. And in colleges and universities, you will hear the same thing. Talagang ang dami rin pong pumapasok na sa ating colleges and universities. We need to provide, to ensure that we are able to unleash the full potential of the Filipino. And that we can do if we have quality universities, more quality universities and colleges.
Yes. Thank you po, Mr. Speaker. I think I'm running out of time. So, dun ko na po tinatapos yung interpellation natin. So, naniniwala din talaga po ako itong kinatawan na ito na hindi tsa-tsa, hindi yung economic tsa-tsa ang sagot doon sa mga pressing problem natin sa ating ekonomiya at sa ating sa ating education or even advertising. Dahil kung tama lang po yung mga economic policies natin, yung mga educational policies natin ay we are on the right direction. So yun po, Mr. Speaker, and thank you, distinguished sponsor. Thank you, Mr.
Thank you
Speaker.
very much, Congressman Castro. Majority Leader.
Mr. Speaker, I move that we suspend in the meantime consideration of RBH number 7. So,
There's a motion to suspend deliberation of RB 87. Any objection? There being none, motion's approved. Majority Leader.
Mr. Speaker,
We move that we recognize Representative Brosas.
Congresswoman Arlene Brosas, what is your pleasure?
yes, Mr. Speaker. Mr. Speaker, I have a personal and collective privilege on the impending strike in FCF Manufacturing Corporation.
Okay, you have 10 minutes. Please proceed.
Thank you, Mr. Speaker. Mr. Speaker, I rise today on a matter of personal and collective privilege to bring to your attention the successful strike vote conducted by the Workers' Union in FCF Manufacturing Corporation inside the Freeport area of Bataan in Mariveles, Bataan, and the alleged attempts to harass the said workers. Una sa lahat, ginagarantiyahan ng ating konstitusyon ang karapatan ng mga manggagawang mag-unyon, ang kanilang makipagtawaran at ang karapatang magwelga, alinsunod sa itinakda ng batas. Bahagi ito ng mga naipagtagumpay na demokratikong karapatan na nakaukit sa saligang batas matapos ang makasaysayang EDSA uprising. Subalit sa aktwal, maraming balakid para malayang matamasa ng mga manggagawa ang mga karapatang ito. Pilit na itinuturing na krimen ang pag-uunyon ng mga manggagawa o di kaya'y ibinabaon sa limot ang karapatan ng bawat manggagawang magtayo o sumali sa unyon bilang plataporma nila sa paggigiit ng nakabubuhay na sahod, regular na paggawa at mas makataong kalagayan ng kanilang kumpanya. Mapagpasyang pinangibabawan ng mga manggagawa ng FCF Manufacturing sa Bataan na karamihan ay kababaihang manggagawa ang mga balakid na ito. Sa isinagawang strike vote mula February 29 hanggang March 3, 1,040 ang bumoto pabor sa welga, habang 100 lang ang tumutol dito. Subsidiary ang FCF Manufacturing ng Fashion Focus Limited na nakabase sa China. at gumagawa ito ng leather bags at wallets ng luxury brands na Coach at Kate Spade. Tinatayang nasa 3,000 ang mga manggagawa sa FCF, kabilang ang mga kontraktual. Ano ba ang dahilan ng pagwewelga ng mga manggagawa ng FCF? 10 pesos na aumento ang ginigit nila sa CBA negotiation, pero 2 pesos lang ang offer ng kanilang management. Malaking insulto ito sa mga manggagawa, lalo't milyong-milyong dolyar ang iniaakyat nila sa malalaking luxury brands. 3 salik ang nakikita ng kinatawang ito ng Gabriela Women's Party kung bakit mahalaga ang napipintong welga sa FCF Manufacturing sa Bataan. Una, ikinasa ang welga sa gitna ng paggunita ng buwan ng kababaihan at ng pandaigdigang araw ng kababaihang anak pawis na may historikal na ugat sa malawakang welga rin ng mga kababaihang manggagawa sa Russia at Amerika. Pangalawa, sa kalagayang humigit kumulang 6% na lang ang unyonisadong manggagawa at sa sitwasyong mabibilang sa daliri ang mga inilulunsad na welga ng mga manggagawa, makasaysayan ng ipinamalas na tapang ng mga manggagawa ng FCF Manufacturing para ituloy ang welga. Pangatlo, sa Bataan din pumutok ang pinakaunang welga sa loob ng Export Processing Zone noong 1982 sa pangunguna ng mga manggagawang kababaihan ng Inter-Asia Garments. Kaya naman, mahalagang masuportahan ang welga ng mga manggagawa ng FCF Manufacturing na ibigay ang hinihiling na 10 pesos na aumento. Sa halip na deployan sila ng mga pulis at militar at sa halip na supili ng kanilang welga, mahigpit na susubaybayan ng Gabriela Women's Party at mga pangmanggagawang organisasyon ang welga sa FCF. Dagdag sahod ang hinihingi nila tulad ng ninanais ng kapulungang ito, kaya mahalagang masuportahan natin sila. Mabuhay ang mga manggagawang kababaihan, itaguyod ang karapatang mag-unyon at magwelga ng mga manggagawa. Maraming salamat, Mr. Speaker.
Thank you very much, Congresswoman Arlene Brosas. Majority Leader.
Mr. Speaker, I move that we refer the privileged speech of Honorable Brosas to the Committee on Rules for proper action.
The speech of Congresswoman Arlene Brosas is referred to the Committee on Rules. Any objection? There being none. Motion is approved. Majority Leader.
Mr. Speaker, still under the unfinished business, I move that we resume consideration of House Bill 9349 under Committee Report 962, and I ask the Secretary General to read the title of the bill.
There's a motion to resume consideration of House Bill 9349, and the Secretary General is directed to read the title.
House Bill number 9349, an act reinstituting absolute divorce as an alternative mode for the dissolution of marriage.
Mr. Speaker, I move that we, the parliamentary status of the bill is we are in the period of interpellation, and I move that we recognize Representative Lagman as to sponsor the bill, and we also recognize the Honorable Rufus Rodriguez to interpolate. So move, Mr. Speaker.
The distinguished representative from Albay is recognized to sponsor the said motion, the said bill, and the distinguished gentleman from Cagayan de Oro is recognized for his interpolation. You may proceed.
Thank you, Mr. Speaker. May I know if the honorable gentleman from Albay will be available to some interventions?
Yes, willingly, Mr. Speaker. I've been long waiting for the distinguished gentleman from Cagayan de Oro City to make his interpellation so that we could have an instructive dialogue and interaction.
Thank you, my distinguished colleague. Thank you, Mr. Speaker. My first point will be a constitutional point. We go to the jugular. In other words, the most important point about the divorce bill that our distinguished colleague is sponsoring. Under the Constitution, Mr. Speaker, Article 17, 18, the family. It states that the state recognizes, Article 14, Section 1, Article 15, Section 1, the state recognizes the Filipino family as the foundation of the nation. Accordingly, it shall strengthen its solidarity and actively promote its development. It says here, strengthen its solidarity and actively promote its total development. So my question is, Mr. Speaker, is it not that the House bill which is being proposed, which is Committee Report 962, reinstituting absolute divorce as an alternative mode for the dissolution of marriage, does this not directly contravene the Constitution of the Republic of the Philippines?
Mr. Speaker, it does not. And this provision in the Constitution is not cast in stone, and it is more of a prescription of a standard or a norm. Even with this constitutional provision, together with Section 12 and Section 2 of Article 15, the Constitution does not prohibit the Congress to enact an absolute divorce law. On the contrary, Mr. Speaker, the 1987 Constitution, commissioners of the 1986 Constitutional Commission, led by Father Joaquin Bernas, unanimously agreed that the Congress can pass an absolute divorce law. The following proceedings are instructive. After the late Commissioner Chito Gaston introduced the aforesaid concepts of marriage and family, Father Bernas rose to interpellate him in this wise, and I quote, Father Bernas, just one question, and I am not sure it has been categorically answered. I refer specifically to the proposal of Commissioner Gascon. Is this to be understood as a prohibition of a general law on divorce? His intention is to make this prohibition so that the legislature cannot pass a divorce law. Mr. Gascon, Mr. Presiding Officer, that was not primarily my intention. My intention was primarily to encourage the social institution of marriage, but not necessarily discourage divorce. Father Bernas, no, my question is more categorical. Does this carry the meaning of prohibiting a divorce law? Mr. Gascon, no, Mr. Presiding Officer. Father Bernas, thank you. In a subsequent proceeding, the following exchange transpired between Commissioners Jose Bengson and Maria Teresa Nieva. Mr. Benson, will this in any way preclude Congress from approving a law on divorce? Nieva, we discussed that yesterday, and I think we reiterated that it does not. Mr. Bengson, it does not. Nieva, no. Mr. Bengson, so even if this section or this sentence is approved, the one referred to by the distinguished Rufus Rodriguez, Congress will still have every right to pass a divorce law under certain circumstances as it may deem fit. It should be underscored, Mr. Speaker, that no commissioner posited a dissenting vote. While it is the obligation of the state to uphold these principles, it is likewise the obligation of the state to rescue couples and children from an irremediably shattered marriage. So many countries, Mr. Speaker, have the same provision on the inviolability of marriage and the state protection to marriage and the family. But all of these countries have legalized divorce in varying degrees of liberality, including notarial divorce in Catholic countries like in Colombia, Brazil, Bolivia, and Mexico, and email divorce in Portugal. For the information of our colleagues and the public, and for the record, allow me to identify these countries. Colombia. The Constitution of Colombia states, the family is the basic nucleus of society. The state and society guarantee the integral protection of the family. An act shall determine the inalienability and unseizability of family patrimony. The family's honor, dignity, and intimacy are inviolable. This is virtually identical with the Philippine Constitution. However, in 2005, or 19 years ago, Colombia liberalized its old divorce law under Decree 4436. Under this new law, if both spouses agree on seeking a divorce, they can do so in front of a notary instead of having to face a family court judge. However, even with its liberalized divorce law, Colombia's divorce rate is still one of the lowest in the world at 0.7% per 1,000 people. Ireland. The Constitution of Ireland provides, the state recognizes the family as the natural, primary, and fundamental unit group of society, and as a moral institution possessing inalienable and imprescriptible rights, antecedent and superior to all positive law. The state guarantees to protect the family in its constitution and authority as the necessary basis of social order and as indispensable to the welfare of the nation and the state. The state pledges itself to guard with special care the institution of marriage on which the family is founded and to protect it against attack. Despite these constitutional provisions, Ireland legalized divorce 28 years ago in 1996. But compared to the rest of Europe and the world, the divorce rate in Ireland, where devout Catholicism is predominantly practiced, is considered remarkably low, with only 0.7 divorces per 1,000 people as of 2023, or not even 1%. Mali. The Mali Constitution provides, Article 6, residence, property, private and family life, confidentiality of correspondence and communications are inviolable. Mali is a predominantly Muslim country where divorce has long been legal, but in 2011, it amended its existing divorce law to allow women to initiate divorce. Let us go to Latin America. In Peru, the Constitution of Peru reads, the community and the state extend special protection to children, adolescents, mothers, and the elderly in society in situation of abandonment. They also protect the family and promote marriage which are recognized as natural and fundamental institutions of society. However, despite this constitutional provision similar to that of the Philippines, Peru legalized divorce 23 years ago in 2001. But as far back as the mid-1400s, during the height of the Inca civilization, divorce could be availed of if a couple was childless. Guatemala, the Constitution of Guatemala provides, invoking the name of God. We, the representatives of the people of Guatemala, recognizing the family as the primary and fundamental genesis of the spiritual and moral values of society and the state as the one responsible for promoting common good. It further states, the state guarantees the social, economic, and juridical protection of the family. Despite this provision, divorce became legal in Guatemala in 1987, or 37 years ago. Despite no false divorce being available, it has the lowest divorce rate in all of Latin America, with 0.2 divorces per 1,000 people as of 2023. This is mostly attributed to cultural norms and the primacy given to the family. Uruguay, the provision of the constitutional provision of Uruguay provides, the family is the basis of our society. The state shall safeguard its moral and material stability so that children may be properly reared within that society. But despite this provision, which is similar to ours, Uruguay legalized divorce way back in 1907, or 117 years ago, under the ground of husband's cruelty, and by 2012, women could petition for divorce without a stated cause. Brazil, the Constitution of Brazil reads, the family, which is the foundation of society, shall enjoy special protection from the state. For purposes of state protection, a stable union between a man and a woman is recognized as a family unit, and the law shall facilitate conversion of such unions into marriage. Again, despite these constitutional doctrines, Brazil legalized divorce in 1977, or 46 years ago. In January 2007, Brazilian couples can undergo a notarial divorce if they have no disputed property and no minor or special needs children. Bolivia. In Bolivia, the Constitution provides, the state recognizes and protects the family as the fundamental nucleus of society and guarantees the social and economic conditions necessary for its full development. It's again similar to the Philippine Constitution. It further says, the state shall protect and assist those who are responsible for the family in the exercise of their obligations. Act number 996, promulgated in 1988, amended the Bolivian Family Code and revised its old divorce statute, stating under Article 207 that men and women have equal rights to start divorce proceedings, and there are three methods of divorce. One, divorce in front of a notary, enabling many couples without minor children and common properties to divorce without the expense and uncertainty of court proceedings. Two, divorce by mutual agreement. And three, contested divorce. In Mexico, the Constitution provides, man and woman are equal under the law. The law shall protect the organization and development of the family. Divorce has legally existed in Mexico for over a century, or since 1914. But since the time of the Aztec civilization in the centuries back, divorce was legal. Both men and women had the right to initiate divorce and had rights over their property and custodianship of their children. Today, there are three types of divorce in Mexico. One, mutual divorce. Two, contested divorce. And three, notarial or administrative divorce. We go to Europe. In Portugal, the Constitution provides under Article 67, family. One, as a fundamental element in society, the family shall possess the right to protection by society and the state, and to the effective implementation of all conditions needed to enable family members to achieve personal fulfillment. Despite this provision, Portugal introduced divorce way back in 1910 and liberalized it further in 2008. The new law abolished the legal concept of fault, and it now allows two persons to lodge an electronic divorce, which is known as the email divorce, to file an electronic request for no-fault collaborative divorce in a non-judiciary administrative entity. In specific cases, with no children, real property, alimony, or common address, a divorce can summarily be decreed within 1 hour. Spain, which brought the religious faith to the Philippines. The pertinent article of the Constitution of Spain reads, "The public authorities ensure social, economic, and legal protection of the family." Spain legalized divorce in 1981, or 43 years ago. In 2005, an express divorce process was introduced for uncontested divorce. Greece. The Constitution of Greece provides the institution of the family being the foundation of the preservation and improvement of the nation, as well as marriage, motherhood, and childhood shall be protected by the state. Again, this is similar to the Philippine Constitution on the protection of marriage and the family. However, as far back as ancient Greece, dating to 14,000 BCE, divorce was already practiced. Moreover, according to the authors of the book, A Brief History of Ancient Greece, Politics, Society, and Culture, divorce did not seem to have been looked down upon in early Greek civilization. In ancient Athens, both husband and wife had the power to initiate a divorce. In modern times, the grounds for filing for a divorce in Greece can be broadly categorized into two types: at fault or contested, and no fault or consensual divorce. Germany. The German Constitution provides marriage and the family shall enjoy the special protection of the state. The care and upbringing of children is the natural right of parents and a duty primarily incumbent upon them. The state shall watch over them in the performance of this duty. At the turn of the previous millennium, on January 1, 1900, Germany already had a divorce law. In 1977, it instituted unilateral divorce with 3-year separation as a requirement. Poland, another Catholic country. Its constitutional provision reads, marriage being a union of a man and a woman, as well as the family, motherhood, and parenthood shall be placed under the protection and care of the Republic of Poland. Poland legalized divorce 78 years ago in 1946. France. the Constitution of France reads, "The nation shall provide the individual and the family with the conditions necessary to their development." In the first French divorce law, the first French divorce law was passed in 1792, or almost 232 years ago, during the French Revolution, and was eventually incorporated into its civil code. After being abolished by the Catholic Bourbon kings in 1816, it was reestablished by law on July 27, 1984. Now let's go to Asia. Saudi Arabia. The Constitution provides the family is the nucleus of Saudi society. The state shall take great pains to strengthen the bonds which hold the family together. Take note of the word strengthen, which is similar to our Philippine Constitution. As a Muslim country, Saudi Arabia has long allowed divorce. Back in 2018, it canceled the House of Obedience article in its marriage law, which grants a husband the right to force his wife to return to her home against her will. As per the amendment in the law, the wife will no longer be forced to return to a married life when she does not want. The cancellation of the article takes into consideration the protection of a woman's dignity and the fact that married life should be based on mutual consent. Let me underscore this. Married life should be based on mutual consent. Vietnam. The state protects marriage and family and protects the interests of mothers and children. In ancient Vietnam, the Hong Doc Code allowed divorce for both husband and wife. Today, there are two types of divorce in Vietnam: fault-based divorce and divorce by mutual consent. Emphasis of Vietnamese culture on the importance of the family and marriage are taught to be by experts to be the reason why divorce has remained at 0.2 divorces per 1,000 people in Vietnam as of 2023. China. The Chinese Constitution provides marriage, the family, the mother, and the child are protected by the state. In 1950, or 74 years ago, the Communist Party introduced a marriage law that abolished feudal marriage practices and introduced a new marriage system based on monogamy, gender equality, and free marriage and divorce. But divorce in China has been possible for at least 2,000 years under the ancient Chinese law, although during those times, divorce can only be initiated by husbands. In 2019, 70% of divorce proceedings in China were initiated by wives. Mongolia. The Mongolian constitution provides men and women shall enjoy equal rights in political, economic, social, and cultural fields and in marriage. State shall protect the interests of a family, motherhood, and the child. Divorce initiated by either spouse was rare but allowed in ancient Mongolia, in the ancient Mongol Empire. Today, Mongolia's family law of 1999 includes two procedures in the dissolution of marriage: judicial or ministerial. In the latter, a couple have consented mutually to divorce and who do not have children under 18 or disputed property can apply for a divorce at the Citizens' Family Registration Office in their city or municipality, and such office is required to act on their application within 30 days. Now let us go to Africa. In Egypt, the Constitution provides the family is the basis of society and is based on religion, morality, and patriotism. The state and society oversee the commitment to the genuine character of the Egyptian family, its cohesion and stability, and the consolidation and protection of its moral values. As a Muslim country, Egypt has long legalized divorce. Even during the reign of the pharaohs, divorce was allowed as evidenced by papyrus, marriage contracts, and ancient documents showing that in certain instances, women were compensated if their husbands divorced them, and the compensation was up to 10 times the value of their dowry. In 2000, President Mubarak signed a law that allows women to petition for divorce on the basis of incompatibility. Ethiopia. The Constitution of Ethiopia reads, "The family is the natural and fundamental unit of society and is entitled to protection by the
Mr. Speaker,
society and the state."
may I ask what is the country you are now referring now?
Ethiopia. Ethiopia.
Ethiopia. Thank you.
Ethiopia.
Can you cite again the constitutional provision?
The civil code was passed in 1960 or 64 years ago, allowing divorce. Algeria. The family gains protection from the state and the society. All individual liberties are carried out within the respect of the rights of others recognized by the Constitution, in particular, the respect of the right for honor, intimacy, and protection of the family. As early as 1984, Algeria already had a divorce law, but it was in 2005 when reforms to the family law introduced additional protection for wives. Somalia. Marriage is the basis of the family, which is the foundation of society. Its protection is a legal duty of the state. Rwanda. The family, being the natural foundation of the Rwandan state, society, is protected by the state. The state puts in place appropriate legislation and organs for the protection of the family in order to ensure that the family flourishes. The predominantly Christian country of Rwanda legalized divorce in August 28, 2016. Angola. The family is the basic nucleus of social organization and shall be the object of a special protection by the state. In 1975, following the independence from Portugal, Angola inherited elements of Portugal's civil law system, and there is a comprehensive family code that sets out the rule on divorce. Libya. The Libyan constitution provides families shall be the basis of society and shall be protected by the state. The state shall protect and encourage marriage. Libya's divorce law was promulgated in 1984, or 40 decades ago. Consequently, all of these countries, both Catholic, Christian, or non-Catholic or non-Christians, have similar provisions in their constitution for the protection of marriage and the family, and that marriage is inviolable. But despite these constitutional doctrines, all of these countries have divorce in varying degrees of liberality. Mr. Speaker. In fact, our proposed bill is much more stricter than the divorce laws in these Catholic and Christian countries. Thank you, Mr. Speaker.
Thank you, Mr. Speaker, distinguished colleague. After Section 1 of Article 15, which states the state recognizes the Filipino family as the foundation of the nation, period. Accordingly, it shall strengthen its solidarity and actively promote its total development. This is now followed, Mr. Speaker, by a provision, direct provision on marriage. And what does Section 2, Article 5 of the Constitution provides? And I will read now the constitutional provision of the Republic of the Philippines. Marriage as an inviolable social institution is the foundation of the family and shall be protected by the state. What is the meaning of inviolable as enshrined in the Constitution? When we say inviolable, it means in all dictionaries, never to be broken. Second, it can never be infringed. Third, it cannot be dishonored. And then other dictionaries will state that it is indestructible, durable, invincible, stable, unassailable, and unbreakable. So my question, Mr. Chairman, is this. Because I have a survey also of this Constitution, as this has been a debate since about 3 Congresses ago. My question to the honorable distinguished colleague is, does the Columbia Constitution states about the inviolability of marriage? Is inviolable found in the Columbia Constitution?
May I now respond? Yes, Mr. Speaker.
Can you read the provisions of Columbia?
Yes, I read it already. I will read it again.
Please repeat.
The Chapter 2 on Social, Economic, and Cultural Rights
Yes.
of the Colombian Constitution, more particularly Article 43, reads in full, the family is the basic nucleus of society. The state and society guarantee the integral protection of the family. An act shall determine the inalienable and unseizable family patrimony. The family's honor, dignity, and intimacy are inviolable. It starts with the families. In other words, this is virtually identical with the Philippine Constitution.
No, Mr. Speaker, with due respect,
Well,
it should refer, the inviolability should refer to marriage and not other provisions.
there can be no family without marriage
No,
No.
there can be families without
or
marriage.
without union.
Many.
Without union. So the family is
il-
based on marriage. And when you protect the family and you make that family inviolable, that also extends to the basic institution which creates the family, and that is marriage. But whatever it is, Mr. Speaker, our Constitution does not prohibit that Congress can enact or cannot enact a divorce law. Nowhere in our Constitution is there a provision which prohibits Congress from enacting a divorce law, including the 1935 and the 1973 Constitution. Despite that all of these doctrinal statements protecting the family, making marriage inviolable, are also present, just like in other countries. What is more inviolable when the constitution of these countries provide that marriage and the family shall be protected by the state. But these provisions do not deter these countries from instituting or legalizing divorce. Because as I've said, these are standards and norms. For example, the Philippine Constitution provides under Section 19 of Article 2 that the Philippines shall develop a self-reliant and independent economy effectively controlled by Filipinos. That is in our Declaration of Principles and Policies. Why is the distinguished gentleman supporting House Resolution number 7 when it detracts from this Declaration of Principle of the Philippine economy effectively controlled by Filipinos? That is the same as these other principles. They are not cast in stone, Mr. Speaker.
Thank you, Mr. Speaker. Clearly, this is about divorce and not the economic amendments to the Constitution. It's clear, therefore,
It's
that
it's the same scenario.
Finish. Colombia, therefore, does not have a direct statement that marriage is an inviolable social institution, unlike the Philippines. I'll go now to the next constitution. How about Peru? Does Peru Constitution states about the inviolable social institution of marriage? Peru.
Let's go to Peru.
Yes.
Peru says, the Constitution, the community and the state extend a special protection to children, adolescents, mothers, and the elderly in the situation of abandonment. They also protect the family and promote marriage, which are recognized as natural and fundamental institutions of the state. What else do we demand from this very important statement? This virtually makes marriage inviolable. But Peru, way back 22 years ago, legitimized divorce.
Mr. Speaker,
You do not need to have that word inviolable because that pertains to a meaning which would cover the protection by the state of marriage and the family. Because if it is inviolable, it needs protection. But all of these constitutional precepts did not prohibit or deter these countries from instituting divorce.
Mr. Speaker, clearly, Peru does not have the word inviolable. And verba legis, in our Constitution, under the principle of verba legis, it is very clear that we have the words inviolable social institution. Clearly, none in Colombia, none in Peru. And go now to Guatemala. Does Guatemala have the word inviolable? Because again, inviolable means unbreakable. It means indestructible. It means invincible, unassailable. That is the meaning of inviolable, which our Constitution states. So maybe know now. Let us go to Guatemala. They have a divorce law, admittedly, but does the Constitution prohibit them because there is an inviolable social institution? Can we have Peru now? Can we, our colleague, give us Peru's constitutional...
The Constitution of Peru does not have the word inviolable.
Yeah.
But it says marriage and the family shall be protected by the state. That is virtually the same. And you cannot be more protective than what the Constitution says. And protection is equated with inviolability because you cannot protect something which could be destroyed. So once it is inviolable, it has to be protected by the state. Again, despite this provision, Guatemala instituted divorce. And let me repeat, despite all of these provisions in our Constitution on the sanctity of marriage, on the inviolability of marriage, on the protection of marriage in the family, the Constitution does not prohibit this Congress from enacting a divorce law. On the contrary, the members of the Constituent Assembly said unanimously that Congress can enact a law on divorce. And we cannot be more papist than the Pope, than those who frame the Constitution of the Philippines.
Again, Mr. Speaker, the Constitution of Guatemala does not state that marriage is an inviolable social institution. Protection, the words protection, special, under any English language interpretation is different from the word inviolable. They have special, they have protection, but it is not synonymous to inviolability, unbreakability, durability. Let's go now to Uruguay. Can you cite if the Constitution states the words inviolability that cannot be violated?
It
You
does
now
not
have the provisions.
It does not, Mr. Speaker, but it provides for prescriptions virtually considered marriage as inviolable because marriage would need the protection of the state. We cannot be very dictionary wise when we interpret constitutions. We are not invoking Webster here in our debate.
I am invoking the Constitution, not Webster. The Constitution says inviolable, and that is why the honorable sponsor admits there is no word of inviolability in the Uruguay Constitution. And it is different when you say protection, special, but inviolability in our Constitution, words are placed there to have a definite meaning. And inviolability has definite meanings all over the world. It is therefore unbreakable. It is therefore unassailable. And it cannot be infringed whatsoever because the word used by the Constitution is inviolable. Now let's go now to Brazil. Does Brazil have the words that marriage is an inviolable social institution? Brazil, what does Brazil say?
Brazil's constitution provides that marriage and the family should be protected by the state.
No, therefore, inviolability, nothing inviolability.
None.
Only protection, Mr.
What-
Speaker.
what
I'm asking
you are-
whether there is inviolability because that will be the difference of our Philippine Constitution. And that is why the Philippine Constitution is unique. It will always protect the family. It will always protect the marriage of union of man and woman. Let's go now to Bolivia.
Let me just say,
Yeah, then Bolivia.
let me just say that despite the presence of the word inviolability in our Constitution does not prohibit Congress from enacting a divorce law, and the commissioners of the 1986 Constitutional Convention said categorically in black and white that Congress can enact a divorce law, despite the presence of the word inviolability in our Constitution.
I have to take exception because what was read in the minutes of the particular issue of divorce, Father Bernas did not categorically say that he's in favor of divorce. He was asking Gascon, and he said, thank you afterwards. So, there is no statement that he would say, I am for divorce. Divorce could be legislated in the Philippines. But let us go now to Mexico.
Now,
Does
Mr.
Mexico
Speaker,
have this?
Mr. Speaker, you don't actually say, I love you, specifically when you mean that you love somebody.
That is a different matter, Mr.
And it's always akin, Mr. Speaker. Because
Never akin. There has to be a categorical statement by Father Bernas. There was none.
let me read again
Yeah.
the
Who said
proceedings.
that? Who said about that?
I'll read the proceedings. Let me go back to that proceedings. Ayan. Father Bernas, just one question.
Yeah, question.
Yes, what do you do when you interpolate? You ask question.
Yeah, but that is this.
Just one question.
Yeah.
And I am not sure if it has been categorically answered. I refer specifically to the proposal of Commissioner Gascon. Is this to be understood as a prohibition of a general law on divorce? Mr. Gascon, Mr. President, Mr. Presiding Officer, that was not primarily my intention. My intention was primarily to encourage the social institution of marriage, but not necessarily discourage divorce. Father Bernas, no, my question is more categorical, that this carry the meaning of prohibiting a divorce law. In other words, Father Bernas wanted to know whether Congress can pass a divorce law despite the provisions on family and marriage. Mr. Gascon, no, Mr. Presiding Officer. So what else would you like
Now, what is the
Bernas
answer of
to
Father
say
Bernas?
that he is in favor of a divorce law? That is very clear in the interchange. And moreover,
Before
that was clarified by Mr.
Before that,
Wilson.
just go to Bernas first.
So even if this section or this sentence is approved, Congress will still have every right to pass a divorce law under certain circumstances as it may deem fit. And let me just add that in a subsequent column or columns in the Inquirer, Father Bernas was in favor of the divorce law.
Well, based on the constitutional minutes, after he said no, it will not prohibit divorce, Father Bernas said thank you and sat down. He did not state that I agree with the position because, Mr. Speaker, all these constitutional minutes and the personal observation of the members of the commission has no weight, persuasive, but is not conclusive. And that's why the Supreme Court, in a line of cases, while they may be persuasive, they are not conclusive. And that is why I am saying that to say that all the Constitutional Commission members were in favor of having a position that divorce can be here is not borne by the records. But let me now go to Mexico. What does Mexico state?
Does not have that inviolability, but it has words and phrases akin to inviolability.
There is no says as akin to. It has to be either inviolable or not. So now we go now to Europe. After we were in South America, in Portugal, does it have the word inviolability, inviolable?
Well, it's obvious there is no word, but there are words and phrases akin to or similar to inviolability. Let me just tell the distinguished interpolator that his time is running out.
No, Mr.
He's asking things which are obvious.
Mr. Speaker, he had a very long time in reading these constitutional provisions. And so therefore, for me, I
No,
have to
no, no, no.
calculate-
I'm not. I'm just concerned that your time is running out.
Yeah, ma-
I don't mean that you should stop. But
Yes,
we have
okay.
rules to follow.
Yes, because he read in a long litany of this constitution. So let's now go to, so Portugal, you admit the word inviolable is not present, distinguished colleague. It's not? It's not present. Portugal.
What do you think? Did you hear me say inviolable in the Constitution of Portugal?
No, Mr. Speaker, I'm just going to...
No, there is none, but there are similar phrases and words akin to.
Now let's go now
inviolability.
to Spain, where we were 330 years, we were under its jurisdiction. The Spain, which provides divorce, does it have the word inviolable social institution?
No, it does not, but with respect to marriage and the family, it provides for the protection of these institutions, akin to inviolability.
So I just go now to the others to shorten my this point. How about Greece, Germany, Poland, and France? Does this constitution have the word inviolable?
Mr. Speaker, the same answer.
So there are none. In the constitutions that we referred to, no statement about inviolability, unbreakability, unassailability. And let's go to Asia. In Asia, how about Saudi Arabia? Is there a word inviolable in the constitution?
Same answer, Mr. Speaker.
Okay, Vietnam,
Same answer, Mr. Speaker.
none. China,
Same answer, Mr. Speaker.
and you know, the constitution of China will not even matter because in China, they have a constitution, but they have no constitutionalism. There's a distinction between having a constitution and constitutionalism. Because in constitutionalism, they have a vibrant judiciary to check. The judiciary of China cannot check the Communist Party of China. So let's forget about Chinese constitution. Let's go now to Vietnam. Same answer.
Same answer.
None. Let's go now to Mongolia.
Same answer.
None also. Ethiopia.
Same answer.
No inviolability. Algeria.
Same answer.
Somalia.
Same answer.
None. Rwanda.
Same answer.
Angola.
Same answer.
Libya.
Same answer.
Therefore, Mr. Chairman, Mr. Speaker, what was recited by the honorable colleague does not fit into our constitutional requirement. And the requirement of inviolability, which was precisely placed by the constitutional framers in 87, which was also found in our family code and so forth, because they want to have stability and unbreakability of marriage. So therefore, clearly, since our Constitution has the word inviolable, any divorce law will violate the Constitution, directly violate the Constitution. In fact, Mr. Speaker, in the case of Imbong versus Ochoa, GR number 20489, April 8, 2014. Does our distinguished colleague know the decision in this case about family as a basic social institution and the marriage?
Yes, that is the leading case where the constitutionality of the reproductive health law was challenged, and the Supreme Court held that the reproductive health law in general is constitutional.
In general, but on the specific issue, Mr. Speaker, because I voted against the RH bill, one of only about 30 who voted against the RH bill during the time of President Aquino. very clearly. What does the Supreme Court say about RH Bill Section 23A2I? This section of the RH law permits RH procedures even with only the consent of the spouse undergoing the procedure, disregarding spousal consent. According to the Supreme Court, this section intrudes into marital privacy and autonomy and goes against, here is the word, it goes against the constitutional safeguards for the family as a basic social institution. That is the Supreme Court. What does the distinguished colleague say about Imbong versus Ochoa on Section 23A2I?
You know, Mr. Speaker, distinguished representative from Cagayan de Oro City, even the Supreme Court can be mistaken. So
concept.
I would not agree to the validity of that ruling of the Supreme Court. But that is the Supreme Court, then let it be so. But most probably in a future case, that can be reversed. The Supreme Court is supreme even in its errors.
So, Mr. Speaker, because the Supreme Court has ruled that this section violates Article 15, Section 1, he would now say, or the distinguished colleague now says, the Supreme Court is wrong. So that
Well, the Supreme Court can be wrong. It's a human institution. But let me say that a woman cannot be a woman if she does not control her own body.
well, that's another issue. What we're saying is that the Supreme Court already ruled in the case of Imbong versus Garcia that it is unconstitutional, this section, because it goes against the constitutional safeguards for the family as the basic social institution. Now, Mr. Speaker, a divorce bill has a weakening effect on the bond of marriage which should be protected and promoted by the state. Article 15, Sections 1 and 2. The grounds stated in the bill will create a trend or culture in the country that the mere finding or commission of such offense or ground warrants or deserves the ending of an inviolable social institution. The very thought that will be injected to the minds of couples that there will be ways to get out of marriage once it gets rocky or problematic will produce in them that mental reservation and a limited sense of spousal commitment that will weaken their strive to work for the solidarity, survival, and flourishing of their marriage, which the state cherishes and protects under the family code. So, Mr. Speaker, though we acknowledge that there are complicated marriages that might need the cutting of ties already, we believe, Mr. Speaker, that the introduction of a divorce law will reduce, if not reverse, the general rule on marriage and the constitutional policy of protecting and strengthening marriages, and hence, it is therefore unconstitutional. In addition, Mr. Speaker, there are studies that say that the presence of a divorce law alters the seriousness of couples to invest in their marriage. Here, we have therefore a study by Betsy Stevenson who said, people invest in their marriages to the extent that they expect them to stay intact, or the intent to which their partners can credibly commit to sharing the fruits of such investments, weakening the marriage contract by making it easier, as what this bill does. For someone to exit the marriage changes the incentive to invest in marriage. Couples are less likely to have children in the first 2 years, are less likely to support each other sequentially through school, and more likely to have 2 full-time workers in the labor force. This observation, Mr. Speaker, concretizes the weakening effect of a divorce law to the spouse's supposed to be lifetime commitment and investment on marriage. We have annulment of marriage, but unlike annulment of marriage in the family law, family code, proceedings which look into the gravity of grounds in order to cut a marital tie, the presence of a divorce law will create a trend or culture that suggests that infirm problematic marriages can and should be terminated at instant. They can terminate at instant emotional distress. May we hear the comment of our distinguished sponsor.
Mr. Speaker, no groom or bride enters marriage with a thought of divorcing later. It is only a skeptic which would say that otherwise. Mr. Speaker, in Te versus Te, the Supreme Court was right when it said that the solution of the marriage is a merciful interment of a long dead marriage. So what we bring to the family court is not a vibrant marriage. It is a marriage which has been shattered beyond repair. As I've said yesterday, it is a cadaver of a marriage which is brought before the family court. Yes, we have annulment, but annulment covers circumstances simultaneous or concurrent with the celebration of the marriage. It does not cover circumstances subsequent to the marriage or during the cohabitation. And many of the causes for divorce are those which happen during cohabitation. So the annulment process is not complete. It's not a full protection for marriages, for spouses who are in irremediably broken marriages, affecting even their children. Mr. Speaker, since the time of the gentleman is expired, may I just say this in conclusion. Despite the presence of inviolability of marriage in our Constitution, the Constitution does not prohibit Congress from enacting a divorce law. What is not prohibited by the Constitution can be done legally, and it is not unconstitutional. Thank you, Mr. Speaker.
Mr. Speaker, that is the opinion of our distinguished colleague. The opinion of the sample representation is the word inviolable is enshrined in the Constitution. And any law that will break this inviolability will be constitutionally infirm. And, Mr. Speaker, I would say annulment right now is about causes that during or before the marriage. Then all we have to do is to amend the family code and add more causes, even circumstances arising after the marriage. In other words, we don't have to go to absolute divorce. Our family code is there. And there's annulment and there's psychological incapacity, Article 36. And, Mr. Speaker, for example, is the gentleman aware that there has been an OCTA, and this is always out, the OCTA research. And the OCTA research group last October 2023, is he aware that according to the survey conducted by OCTA research group last 2023, 51% majority, Mr. Speaker, oppose the legalization of divorce in the country, with 41% in support and 9% undecided. So those who support the divorce bill is only 41%. There are 51% opposed, others as undecided. And I will present this in my next time to interpolate. I will show here the table to be able to show that in the details of the survey, we saw that across all economic classes of A, B, C, and D, E, opposition against divorce is greater. And that is why if the distinguished colleagues insist that I terminate now, I still have so many questions, so may I just request the Honorable Majority Leader to be called tomorrow. Because look at this, I'm still going to the literature on the effects of divorce everywhere in the world.
In other words, the distinguished Rufus Rodriguez wants a second round? Then
No, continuation, not a second round, Mr. Speaker,
How
because
can you continue something which has expired already?
that is the decision of the Speaker.
We have
Because
rules
it is
to follow.
always extended if you want to extend it.
We have
That is
rules to
why
follow.
I am requesting the Speaker to continue my interpellation because our sponsor is bringing some fundamental change to our married life, to marriage, to family. So fundamental that the Constitution is really affected and will really be able to have the constitutional effect. And that is why, Mr. Speaker, I think he should allow us, when we have a debate, we always allow our distinguished colleague to finish his interpellation because in the interest of informed choice of our members of the House of Representatives, a interpellator, a member of Congress, should be able to be given time so that the records will bear this out. And in other words, it will be recorded and they will know what has been debated on. So my request,
Thank
our
you very-
Speaker, to rule.
Mr. Speaker,
If I can
Session
continue.
suspended.
Mahaba pa ito.
tuloy mo na lang. Rufus, just continue.
Oh,
Pwede mauna kami bukas. Ha? Because
Session resumed. Majority Leader.
Mr. Speaker, we note the request of the Honorable Rufus Rodriguez, and I move that we suspend the consideration of House Bill number 9349 until tomorrow, and with the assurance that the Honorable Rufus Rodriguez will be given priority in the interpellation tomorrow.
So
Yes, so move, Mr. Speaker.
there's a motion that we will continue consideration of House Bill 9349 tomorrow. Is that correct? Majority
Suspend-
Leader?
Mr.
Suspend
Speaker.
consideration for today until tomorrow.
Mr. Speaker,
Yes, Congressman
well,
Lag.
I agree to that with the Colatilia that if possible, this bill should be called first after the reference of business so that we can finish the interpellation tomorrow, because I understand that Congressman Tambunting also wants to interpellate.
We will take
And
note of...
if we could finish this bill tomorrow,
Yes. So
I will truly appreciate it.
we will take note of your request, Congressman Lagman, and I'm sure the majority will consider such requests insofar as the House bill will be tackled in your preferred time, given that there's a lot in agenda for tomorrow. Majority Leader.
Mr. Speaker, there's a motion to suspend the consideration of House Bill number 9349.
So there's a motion to suspend consideration of House Bill 9349. Is there any objections? There being none, motion is approved. Majority Leader.
Mr. Speaker, may we acknowledge the guests of Congressman Christian Teliap and Kabayan Party List Congressman Ron Salo. They are barangay captains of the Municipality of Victoria and Municipality of San Jose, Province of Tarlac, headed by ABC President Bonifacio A. Francisco and ABC President Joselito Capitulo. Councilor Calvin Sarja of Kabayan Party List as part of their capacity building and benchmarking activity here in Metro Manila.
Sa mga panauhin ng ating kagalang-galang na kinatawan mula sa Tarlac at mula sa party list ng Kabayan, namely Congressman Christian Yap and Congressman Ron Salo, sa lahat ng mga nakaberde dyan sa kanan, malugod po namin kayong tinatanggap sa Kongreso. Welcome to the House of Representatives. Majority Leader.
Mr. Speaker, may I humbly request that we acknowledge the presence of the guests of Congressman Edsel Lagman. They are the members of the Divorce Pilipinas Coalition, namely Ms. A.J. Alfafara, Mila Milikdem, Evelyn Polognon, Rex Lanos, Heidi Sanchez, Clarissa Gabriel, Michelle Bulang, Raquel Marquez, Helen Fernandez, Marcelina Esteban, Sara Heon, Melinda Coronacion, Regina Deloso, Arien Romero, Divina Oluguer, Edgar Durano, Luisito Ditan, Rudy Malikdem, Edna Crisol, and Maricar Go.
To the guests of Congressman Edsel Lagman from Divorce Pilipinas Coalition, welcome to the House of Representatives. Majority Leader.
Likewise, Mr. Speaker, I humbly request that we acknowledge the presence of the guests of Congressman Christopher Son Coco M. Yap. It is Attorney Gary Manigo.
To the guests of Congressman Coco Yap, mula po sa Southern Leyte, Attorney Gary Maningo, welcome to the House of Representatives. Majority Leader.
Likewise again, Mr. Speaker, I humbly request that we acknowledge the presence of the guests of the 1st District Bukidnon Representative Jose Manuel F. Alba. They are the barangay captains of the municipality of Baongon, Bukidnon, and will be led by Mayor Rogelio Haraula. They are Honorable Rogelio Haraula, Honorable Billy Puclao, Honorable George Buco, Honorable Rudy Haraula, Honorable Robert Yare, Honorable Gelbes Vergara, Honorable Ramel Haveniao, Honorable Jaime Magno, Honorable Elmer Bansilay, Honorable Raymond Boer, Honorable Danilo Ortizano, Honorable Avelina Batal, Honorable Joseph Dioxon, Honorable Rolando Tuto, Honorable Marlon Babion, Honorable Annabel Bahuyo, and Honorable Joseph Bahuyo.
To the guests of Congressman Alba from the province of Bukidnon, welcome to the House of Representatives. Majority Leader.
Mr. Speaker, I move that we take up the business for the day. And under the business of the day, we take up the consideration and approval and second reading of the following House Bill number 9936, Committee Report 996. And may we ask the Secretary General to read the title of the bill.
There's a motion to approve on second reading for consideration House Bill 9936, and the Secretary General is directed to read the title of the said bill.
House Bill 9936, an act allowing the Department of Education the flexibility to determine the pedagogical approaches to be implemented in the basic education curriculum, amending for the purpose Section 5 of Republic Act number 10533, otherwise known as the Enhanced Basic Education Act of 2013.
Majority Leader.
Mr. Speaker, I move that we open the period of sponsorship and debate for House Bill number 9936.
Is there any objection? There being none, your debate is open. Majority Leader.
Mr. Speaker, I move that we recognize Representative Honorable Roman Romulo to sponsor the House Bill, and consequently to recognize also Representative Manuel for his interpellation. So moved.
The sponsor of the House Bill, Congressman Roman Romulo, you are now recognized.
Thank you, Mr. Speaker. Majority Leader, esteemed colleagues, I rise today to address this august body to present House Bill number 9936, titled An Act Allowing the Department of Education the Flexibility to Determine the Pedagogical Approaches to be Implemented in a Basic Education Curriculum, amending for the purpose Section 5 of Republic Act number 10533, otherwise known as the Enhanced Basic Education Act of 2013, which I have co-authored with the Honorable Michi Kahayon Uy. The lamentable state of our education cannot be attributed to any single issue. It is many issues that this representative has been seeking to address in the various measures that we have authored and sponsored during this representation's term in Congress. I stand before you and look positively towards your continued support in putting in place effective solutions which seek to address the issues plaguing our education system. The K-12 curriculum currently uses the spiral progression approach across subjects, which allegedly is designed to build on the same concepts in each grade level and develop in increasing complexity from kinder to grade 10. Unfortunately, the introduction of the spiral progression approach, in lieu of the previous approach wherein the Department of Education had the free hand to determine, based on their judgment, what approach would be best used in order to ensure of resources. In fact, in one of the reports of the EDCOM 2, it is stated that a more flexible pedagogical approach is recommended, wherein teachers will be able to utilize the appropriate approach or set of approaches that considers the diversity of learners, subject matter, classroom situation, and other essential factors. It is a basic rule that unless otherwise deemed necessary, legislation should constrain itself to the broad strokes of policies and leave the details of the implementation to the expertise of the implementing agencies. Thus, in our amendment, we will allow the Department of Education to employ the approach it deems most effective to ensure the mastery of knowledge and skills after each level. We also place a safeguard that any such approach and curriculum implemented shall be subject to periodic review of not less than once every 5 years, unless circumstances necessitate an earlier period to determine the relevancy and effectiveness in achieving educational goals. This is only so that we can also assure ourselves that we keep abreast of the best pedagogical practices in the delivery of education to our learners, demonstrating our commitment to continuous improvement and excellence in education. Colleagues, this bill represents a pivotal step towards revitalizing our education system, one that is responsive to the evolving needs of our learners and the demands of the 21st century. I urge this House to support this crucial legislation as we strive to deliver quality education that empowers our youth and secures the future prosperity of our nation. Thank you, Mr. Speaker, and I'm ready to take any questions.
Thank you very much, Congressman Roman. Majority Leader.
Mr. Speaker, I move that you recognize Representative Manuel of the Kabataan Party List for this
Congressman
interpellation.
Manuel, you're recognized.
Thank you, Mr. Speaker. Will the good sponsor yield to a few questions?
Yes, gladly. To the gentleman from the Kabataan Party List.
Thank you, Mr. Speaker. Matanong ko lang po, Mr. Speaker, in a nutshell, ano po itong spiral progression at bakit po explicitly ito nilagay dati sa batas? Ano po ang naging reasoning? Kasi ako, Mr. Speaker, nagtataka ako bakit kinailangan na ilagay talaga siya. Ano? And I actually agree dun sa intent nitong panukalang batas na dapat hindi nakaspecify ang ganong iisang pamamaraan lamang. So, again, Mr. Speaker, ano yung spiral tapos bakit siya nakalagay talaga?
Well, basically, Mr. Speaker, the gentleman from the Kabataan Party List, the spiral progression cuts up or divides a subject matter into different competencies, and then the purpose is for each competency to be taught in different levels. Why it was introduced, why it was specified in the 2013 law, to be honest, I am not aware, but probably it is also due to the influence of many international papers. During that time, many presented papers saying that in certain countries, this was used. In fact, up to today, Honorable Manuel, those who are championing this specific pedagogy cites first world nations, but they fail to consider that the Philippines is not the same as all other countries. We have a different education environment. There are needs that we have to also adopt and adjust to. And I think allowing the DepEd that flexibility will again enable learners and our teachers to be able to reach that potential.
Thank you, Mr. Speaker. Next, Mr. Speaker, nung inimplement na natin and kasama nga ang itong spiral progression, ano ang mga tampok na kahirapan na experience ng ating mga paaralan and of course teachers and students dahil nga minamandate talaga itong spiral progression?
Yes. And the EDCOM 2, in fact, did some FGD, focal group discussions with teachers. And in these focal group discussions with the teachers here in Metro Manila, and it also happened in some provinces, the common complaint really was that there was a lack of preparation, because even from the point of view of a teacher to implement a spiral progression requires training and also requires textbooks, materials, so that they can be properly guided. But all these are lacking. In fact, even our parents, even many of our students complain about the fact that because they do not get it in one whole quarter, the mastery of a particular subject, then it leads to them not being able to, in fact, master the whole program. In fact, Honorable Manuel, taking a look at the PISA examination, the SEA PLM examinations, the TIMS examination, the PISA, we had two already, 2018, 2022. The PISA exam are subjects that are foundational subjects: reading, mathematics, and science. In all three, in 2018, we did not fare well. In 2022, we may have improved, but we did not fare well. Meaning, in the foundational subjects, we have to work on that. And as you earlier asked, what is spiral progression? It works on the foundations. So we must have a mastery first of the foundational subjects, the foundational skills. And our results show that we must first focus on this. And we must not complicate the learning of our children.
Hearing that, Mr. Speaker, I would agree with the sponsor na actually hindi nagdulot ng significant na improvements ang pagre-require ng pagtuturo using spiral progression. Kaya mas mainam na hayaan natin ang ating agencies and of course in consultation with our teachers and the other stakeholders kung ano talaga ang based on their practice yung magiging pinakamainam na mga pamamaraan para ituro ang iba't ibang subjects sa ating basic education. With that, Mr. Speaker, I thank the sponsor for answering our questions.
Thank you, Honorable Manuel.
Thank you very much, Congressman Raul Manuel. Yes, Majority Leader.
Mr. Speaker, there being no more interpellators, I move that we close the period of sponsorship and interpellation and debate.
Is there any objection? There being none, the period of sponsorship is now closed. Yes, Majority Leader.
Mr. Speaker, I now move that we open the period of amendments for House Bill number 9936.
Is there any objection? There being none, period of amendments now open. Majority Leader.
Mr. Speaker, there being no committee amendments, I move now that we proceed with the individual amendments.
There being no committee amendments, we will now proceed to individual amendments. Is there any objection? There being none, motion approved. The chair recognizes Congresswoman Stella Kimbo from Marikina.
Mr. Speaker,
Mr. Speaker, I move that we close the period of amendments.
Period of amendments is now closed. There being no objection. Majority Leader.
Mr. Speaker, I move that we approve on second reading House Bill number 9936 as amended.
There is a motion to approve House Bill 9936 as amended. All those who are in favor say aye. Aye. All those who are in favor say nay. The ayes have it. House Bill 9936 is approved on second reading. Congratulations, Majority Leader.
Thank you, Mr. Speaker. Thank you, Majority Leader.
Mr. Speaker, I move that we consider on second reading House Bill number 9978 as contained in Committee Report number 972, and may I request that the Secretary General be directed to read the title of the...
There's a motion to consider House Bill 9978, and the Secretary General is hereby directed to read the title of the House Bill.
House Bill 9978, an act providing for a moratorium on student loan payments during calamities, disasters, crisis situations, and other emergencies.
Majority Leader.
Mr. Speaker, I move that we open the period of sponsorship and debate, and also move to recognize Representative Mark Go to sponsor the bill.
The period of sponsorship is now open, and the chair recognizes Congressman Mark Go.
Thank you. Thank you very much, Mr. Speaker. Good evening, my dear colleagues. It is with pride that I stand before you this afternoon or this evening to sponsor House Bill number 9978 under Committee Report 972. This bill, which was reported out by both the Committee on Higher and Technical Education and the Committee on Disaster Resilience, provides for a moratorium on student loans during calamities, disasters, crisis situations, and other emergencies. Mr. Speaker, the Commission on Higher Education implemented the Study Now, Pay Later program from 1995 to 2017, which released about 474 million pesos in loans that benefited 12,476 student borrowers. However, this loan was discontinued with the enactment into law of Republic Act number 10687, otherwise known as the Unified Student Financial Assistance System for Tertiary Education Act, or the UNIFAS law. In 2015, which provides scholarships, grants in aid, and national student loan program under the UNIFAS board. This loan program was further amended through its incorporation in the Universal Access to Quality Tertiary Education Act under Republic Act 10931 and renamed as the Student Loan Program for Tertiary Education. Mr. Speaker, we all know that the Philippines is located in the typhoon belt and the Pacific Rim of fire. Hence, typhoons, earthquakes, and volcanic eruptions which wreak havoc on the lives of our people have become common occurrences. Many Filipinos have become victims of these natural calamities, not to mention being affected by fires which result to the destruction of their homes or living in conflict-affected areas and needing to flee to avoid being caught in the crossfire, as well as accidents and various forms of tragedy, crisis, or emergency situation. Mr. Speaker, the bottom line is many of our families under these conditions are greatly affected. Mr. Speaker, this bill seeks to provide adequate protection and relief to students and their families affected by calamities, disasters, emergency, or crisis situations, and who have student loans by imposing a moratorium on the payment of all fees, interest, and other charges on loans for higher education and technical vocational education, as well as training incurred by students enrolled in public or private HCIs and TBIs in relation to student loan programs administered by the schools themselves or by UNIFAS board or other government agency or its instrumentality. Mr. Speaker, this legislative proposal further enumerates the criteria for imposing a moratorium, which include the following. First, a declaration of a state of calamity or emergency by the President of the Philippines, the area in which, number two, the student temporarily or permanently resides was affected by a disaster, calamity, emergency, or crisis situation. And number three, notwithstanding the preceding requirements, the student or his or her family has incurred injuries or damages during a calamity, disaster, emergency, or crisis situation. Mr. Speaker, the objective of this piece of legislation is to ensure access of students to quality and affordable education at all times. With the moratorium, we can help protect and shield our students and their families from the financial strain of unforeseen natural or man-made occurrences. Most of all, we can help them avoid further devastation that would shatter their hopes and dreams of completing their education for a brighter future. Mr. Speaker and our esteemed colleagues, I humbly urge you to join me in pushing for the immediate passage of this measure. Again, thank you very much at magandang gabi po sa inyo lahat.
Thank you very much, Congressman Margo, Majority Leader.
Mr. Speaker, there being no interpellators, I move that we close the period of sponsorship and debate.
There's a motion that we close the period of sponsorship and debate. Any objections? There being none, motion is approved. Majority Leader.
Mr. Speaker, I now move that we open the period of amendments.
Is there any objection? There being none, period of amendments is now open.
Mr. Speaker, there being no committee and individual amendments, I move that we close the period of amendments.
There's a motion to close the period of amendment, there being no committee or individual amendments. Any objections? There being none. Majority Leader.
Mr. Speaker, I now move that we vote on second reading House Bill number 9978 and consider its approval.
There's a motion that we approve House Bill 9978. All those who are in favor, please say aye.
Aye.
All those who are not in favor, please say nay. The ayes have it. House Bill 9978 is hereby approved on second reading. Congratulations.
Thank you very much, Mr. Speaker, Mr. Majority Leader.
Majority Leader.
Mr. Speaker, I now move that we consider House Bill number 9982 and ask the Secretary General to read the title of the bill.
There's a motion to consider House Bill 9982, and the Secretary General is hereby directed to read the title of the House Bill.
House Bill 9982, an act strengthening the establishment and operation of all public and private higher education institutions.
Majority Leader.
Mr. Speaker, I now move that we open the period of sponsorship and debate and likewise recognize the sponsor again, Mr. Representative Mark Go.
There's a motion to open the period of sponsorship and debate. There being no objection, motion is approved. Congressman Mark Go, you're now recognized.
Thank you, Mr. Speaker, and my dear colleagues. Isa pong mapagpalayang gabi sa ating lahat. I am honored again to stand in this august chamber to sponsor House Bill 9982 in substitution of House Bill number 7990, which strengthens the establishment and operation of higher education institutions composed of public and private colleges and universities. As of academic year 2022-2023, Mr. Speaker, there are 2,424 HCIs, which include 113 state universities and colleges and their campuses, 136 local universities and colleges, and 1,729 private HCIs, as well as 13 government schools supervised by the Commission on Higher Education. All these HCIs, Mr. Speaker, have a total enrollees of 4.4 million. Mr. Speaker, Section 4, Article 44 of the 1987 Constitution has mandated the state to recognize the complementarity roles of public and private institutions in the educational system and to exercise reasonable supervision and regulation of educational institutions. This bill, Mr. Speaker, promotes the complementarity of more than 2,000 higher education institutions by harnessing their strengths and enhancing their capacities to produce highly skilled and globally competitive graduates and professionals. Indeed, Mr. Speaker, both public and private HCIs play vital roles in the education system. Their coexistence allows for a diverse, dynamic, and balanced educational landscape and helps cater to the varied educational needs of the Filipino people. Their complementarity develops and strengthens the educational system. Under a complementary relationship, they share resources and capabilities for promoting education as a fundamental human right. We all know, Mr. Speaker, that HCIs vary in faculty qualifications, infrastructure, and teaching methodologies. This diversity necessitates reasonable supervision and regulation to produce the skilled workforce needed for economic development. Reasonable regulation ensures consistency, quality, adherence to standards, and uniformity of educational achievements across this diverse landscape. Thus, Mr. Speaker, this bill mandates the Commission on Higher Education and other regulatory agencies to provide effective central policy direction and implement programs and mechanisms to ensure that quality education is accessible to all. This reasonable regulation shall focus on, number one, the imposition of reasonable requirements for the establishment of HEIs, as well as their conversion into universities. Two, setting of the criteria for the issuance of permits to operate and recognition of degree programs. And three, providing incentives and autonomy to HEIs that consistently demonstrate and adhere to the standards of excellence, as well as the recognition of centers of excellence or COEs and centers of development. On providing autonomy and developing COEs and CODs, Mr. Speaker, such is of utmost importance considering that the Second Congressional Commission on Education, or EDCOM-2, has reported that for the last 20-year period, from 2001 to 2021, the number of autonomous HEIs increased by only 36, from 53 to 89, and only 182 out of 2,000 HEIs nationwide have Center of Excellence or Center of Development. Mr. Speaker, while this legislative proposal states that the external governance of all HEIs and their programs, except for the University of the Philippines and the Mindanao State University System, shall be under the oversight function of the CHED, it also provides that their internal governance shall be left to the respective governing boards and administrative offices. Rest assured, Mr. Speaker, that my fellow legislators, that government regulatory policies do not suppress academic freedom, which is principal to the intellectual growth and development of the people. This bill, therefore, provides a conducive atmosphere for speculation, experimentation, and creation, where the four essential academic freedom of the HEIs, such as who may teach, what to teach, how to teach, and who to teach, shall prevail. Mr. Speaker and my dear colleagues, in recognition of public and private HEIs as essential players and partners in the educational system, especially in ensuring the continuous learning of the Filipino people to sustain our beloved country's economic growth, I humbly solicit your support for the immediate passage of this measure. Again, thank you very much at magandang gabi po sa inyo lahat.
Thank you very much, Congressman Mark Go, Majority Leader.
Mr. Speaker, I now move to we recognize Representative Manuel of the Kabataan Party List for his interpellation.
Congressman Raul Manuel, you're recognized.
Thank you. Good evening, Mr. Speaker. Would the sponsor yield to a few questions?
Yes, Honorable Manuel.
Thank you, Mr. Speaker. Una po, Mr. Speaker, I'd like to seek clarification about the role of CHED should this bill, House Bill number 9982, will become a law. Mula sa current na function ng CHED, Mr. Speaker, ano ang magiging direction? Will CHED have more powers in terms of regulation? Will it have less?
Ang objective po natin dito ay magkakaroon ng setting up of minimum requirements ang CHED for the different HEIs in the country. And for those that are doing well, those who will be considered to be COE, or so-called Center of Excellence and Center of Development, the incentive there for them is there will be minimal supervision on this to the extent that they will be given free leeway in determining programs that they would like to implement in the respective colleges or universities.
So, kung ganun, Mr. Speaker, ibig sabihin para sa mga higher education institutions na well-performing, ibig sabihin ba ay mababawasan ang trabaho ng CHED sa kanila in terms of supervision or regulation?
that might happen, Honorable Manuel, Mr. Speaker.
Okay, Mr. Speaker, pagdating naman po sa concept na academic freedom, dahil nung tingnan po natin ang panukalang batas, mas ang nire-refer po niya na academic freedom ay academic freedom ng mga educational institutions natin. It's more of how they are being empowered to create their own policies as to how they will administer themselves. Mr. Speaker, will the bill also cover, halimbawa, ang academic freedom naman ng, say, sectors within the learning institution, for example?
Yung pong gusto nating strengthen dito are the public and private education institutions. So yung academic freedom ng mga iba't ibang sektor sa university ay mananatili po yan. Lalong-lalo na yung mga estudyante at mga guro sa iba't ibang pamantasan ng ating bansa.
Yeah. Mr. Speaker, we are raising that point dahil gusto po nating mas maging encompassing ang ating approach when it comes to academic freedom. Lalo na aside from the academic freedom of educational institutions themselves, no, edi nandyan din po ang academic freedom ng iba't ibang sectors. For example, Mr. Speaker, nasa International Covenant on Economic, Social, and Cultural Rights, and to quote Article 13 of that international document, Mr. Speaker, it says that, and I quote, members of the academic community, individually or collectively, are free to pursue, develop, and transmit knowledge and ideas through research, teaching, study, discussion, documentation, production, creation, or writing. Academic freedom includes the liberty of individuals to express freely opinions about the institution or system in which they work, to fulfill their functions without discrimination or fear of repression by any state or any other actor, to participate in professional or representative academic bodies, and to enjoy all the internationally recognized human rights applicable to other individuals in the same jurisdiction. End of quote. So ang point po natin, Mr. Speaker, ang observation po kasi natin may mga pagkakataon na academic institutions use their academic freedom, and at times ay bumabangga naman yun sa ano naman ang academic freedom ng mga sectors, may it be teachers, personnel, or students. So ang gusto po nating assurance, Mr. Speaker, is that yung academic freedom na gusto nating i-guarantee sa educational institutions would not be abused against dun sa interest ng ating mga sectors.
Definitely, that's not the intent of this particular measure, Honorable Raul Manuel and Mr. Speaker. That's not the intent of this bill, that we will give the academic freedom to the educational institutions at the expense of the other sectors in the university. Definitely. We should have equal exercise of academic freedom among all the sectors in the university. Mr. Speaker, Honorable Manuel.
Okay, with that, Mr. Speaker, I'm glad of that assurance, and this is where I end my interpellation. Thank you, Honorable Chairperson Mark Go.
Majority Leader.
Mr. Speaker, there being no more interpellators, I move that we close the period of sponsorship and debate.
There's a motion to close the period of sponsorship and debate. There being no objection, motion is approved. Majority Leader.
Mr. Speaker, I now move that we open the period of amendments.
Is there any objection? The period of amendments is now open. Majority Leader.
Mr. Speaker, there being no individual and committee amendments, I move that we close the period of amendments.
There being no individual or committee amendments, the period of amendments is now closed. Any objection? There being none, motion is approved. Majority Leader.
Mr. Speaker, I now move that we consider for approval on second reading House Bill number 9982. So moved.
There's a vote. There's a motion that we approve House Bill 9982. All those who are in favor, please say aye.
Aye.
All those who are not in favor, please say nay. The ayes have it. House Bill 9982 is now approved in second reading. Congratulations, Congressman Mark Go, and to the Secretariat. Majority Leader.
Mr. Speaker, I now move that we take up admin matters, and under that, I move that we designate the following members to the Bicameral Conference Committee on the disagreeing provisions of House Bill number 7819 and Senate Bill number 2492 on declaring the maritime zones under the jurisdiction of the Republic of the Philippines. Number 1, Representative Maria Rachel Arenas. Number 2, Representative Raul Buboy Tupas, Representative Rufus Rodriguez, Representative Neptali Gonzalez, Representative Emilio Tanhuatco, Representative Francisco Benitez, Representative Sergio Dagook, and number 8, finally, Representative Ramon Gutierrez.
Is there any objection to the motion? There being none, motion is approved. Majority Leader.
Mr. Speaker, I now move that we designate the following members to the Bicameral Conference Committee on the disagreeing provisions of House Bill number 6558 and Senate Bill number 2386 on instituting reforms in the real property valuation and assessment in the Philippines. Number 1, Representative Jonathan Keith Flores. Number 2, Representative Loreto Acharon. Number 3, Representative Joey Salceda. Number 4, Representative Steve Chongbian Solon. And number 5, Representative Sergio Dagook. So move, Mr. Speaker.
Is there any objection to the motion? There being none, the motion is approved. Majority Leader.
Mr. Speaker, I move that we change the referral of the following measures. Number 1, House Bill number 1343 from the committees on Agriculture and Food and Government Enterprises and Privatization to the Committee on Agriculture and Food. Number
Is there
2,
any objection to the motion? There being none, motion is approved.
Number 2, House Bill number 1479, violence, harassment, and intimidation and other criminal acts committed before, during, and after the conduct of the 2023 Barangay and Sangguniang Kabataan elections from the Committee on Suffrage and Electoral Reforms to the Committee on Public Order and Safety.
Is there any objection? There being none, motion is approved. Majority Leader.
House Bill number 1497, allegations of fraud, anomalies, and other irregularities in the conduct of the Barangay and Sangguniang Kabataan elections on October 30, 2023, from the Committee on Suffrage and Electoral Reforms to the Committee on Public Order and Safety.
Is there any objection? There being none, motion is approved. Majority Leader.
Mr. Speaker, I move that we adjourn session until tomorrow at 3 p.m. March 13.
On what date?
March
13, 2024.
There's a motion to adjourn session until tomorrow, March 13 at 3 in the afternoon. No objection. Session adjourned.